Do I have to share my inheritance with my spouse? Hi, I'm Bill Farias, founder of Farias Family Law, and we met with someone about a month ago who is dealing with this issue. He wants to move forward with divorce, but is in the process of inheriting some assets from his deceased parents, and he's afraid that his spouse is going to get a chunk of those assets in divorce. There are three main factors to consider when trying to gauge what your risk is of your inheritance being included in the marital pot and actually divided in divorce. Number one, the timing of when you received that inheritance is important. So if you receive that inheritance, for example, after there is a divorce filed, let's say the divorce is pending, then there is a better chance that the judge will allow you to keep most or all of it. If you received the inheritance before the marriage, before you had an economic and financial relationship with your spouse, then there is a greater chance that the judge will allow you to keep most or all of it. Now, the only way to come close to 100% in protecting your premarital assets is with a prenup. But absent a prenup, that is still something the judge will consider. If it was before the marriage that you received the inheritance assets, that works in your favor in the sense that there is a better chance that you will be able to keep most or all of it. Another significant factor is commingling, and that's basically a sort of a legal term that essentially means mixing. If your inheritance assets are mixed with your marital assets, then there is a greater chance that those inheritance assets are going to be included and divided in the divorce. And so keeping those inheritance assets separate, only in your name, is important in terms of protecting them. It doesn't guarantee that you're going to keep most or all of them, but it helps. Next, length of the marriage. So generally, the longer your marriage, the more likely it is that the judge will, at the very least, take into consideration your inherited assets in divorce. And so if you have a short-term marriage, 2 years or less, very, very low risk that anything you inherit is going to be included in the marital pot and actually divided. But if you have a 20-plus year marriage, then there is a much higher risk of those assets being included, or at the very least weighed heavily when the judge is figuring out how to divide all of the assets. And so these three significant factors are sort of intertwined. So no single factor will necessarily carry the day, but all three of them are important. When did you inherit the property? Was it before the marriage or after a divorce was filed? Was your property or your assets, were they commingled with marital property? If so, there's a greater risk that they're going to be included in the marital pot and divided. And what's the length of the marriage? The longer the marriage, the more likely it is that those assets will be divided. You have any other questions on this? Call us 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel, share it with anyone you think might benefit from it, and you can find us on social at Farias Family Law. Thank you. Have a good day.